you're really doing that planning and that legwork for the people who are going to have to take care of things once you're gone. And sometimes there's an easier way to get to that same result.
So I had a client ask me the other day, because they were coming in and they were basically just wondering broadly, what is estate planning? And I thought about that for a second, and I was wondering what your take would be.
You would get that question. People ask what you do, and you say, well, I do estate planning, and what is that?
Yeah.
So what is that? That is helping people establish documents that are going to set them up for an easy transition of assets, or hopefully an easier transition of assets if they pass away. Setting up who they want to manage the transition of their assets and the close of their financial life if they pass away. But it's also making sure that if they don't pass away but they're incapacitated, they've got the documents in place to make sure that somebody can take care of them and take care of their financial affairs, because those things often get left hanging when somebody is incapacitated, if they're in an accident, can't act for themselves. What do you say when people ask?
I like the last part you just hit on, because whenever I deal with a client who's closer to my age, I always tell them the most important documents are your advance directive and your financial power of attorney, because those are the ones most likely to come up in the short term, and those are basically the ones that deal with what happens if you're incapacitated but still alive. And so if you're in your 30s, 40s, 50s, those are far more likely to get used than a will, hopefully, knock on wood.
Right.
Yeah.
That's really valid, and we hear too, well, I don't really have anything, I don't really need anything, why do I need to have estate planning documents? Well, you have something, you probably have something, you might have kids, you might have a house, you might have a retirement account. Somebody has to deal with those in both of those situations, and maybe you don't have a huge, enormous estate, but you have something, and somebody needs to help you take care of those if you can't take care of it for yourself.
Absolutely. Odds are it's important to you, even if it doesn't seem like a lot. And if it's important, you should do something to protect it.
Right. And the law will provide a mechanism if you don't have documents in place. Putting those documents in place is your ability to control those decisions and take them out of the hands of the probate court judge and what Georgia law says and bring them back to your own control.
Yeah.
And I think that's a point that a lot of people miss. This is your opportunity to make sure that things are handled the way you want them handled.
No, it's a great point. Who do you want making your decisions? Do you want you to do it, or do you want some judge down the road who you've never met before to do it?
Right, and picking guardians for your children. Do you want to be the one to pick those, or do you want the judge to decide? You have the chance to do it yourself. You should take that chance.
This is one of the most common misconceptions with estate planning, which is mainly that it is solely for rich people, solely for wealthy clients. Trust can only help those above a certain net worth, and that's just absolutely not true. No,
the understanding of the things that can be managed in estate planning documents and knowing the various types of estate planning documents that you can have, I think that's a really misunderstood topic, generally speaking, and talking with an advisor and finding out all the options that can address situations in your life. It is definitely not for people above a certain income level. It is really a tool for people to control how they want their assets to be managed, mitigate taxes, mitigate controversies between family members. So really there is no upper level and there's no minimum that you need to have in order to have successful estate planning, and everyone should really have it.
No, and to that point, trusts in general are not just for when you have a certain amount of assets and you want to keep them out of your estate. A revocable living trust is a device we use all the time, and it can be helpful for helping to guide property. It can be helpful if you own real property in multiple states. I'm sure I'm missing things.
No, I think that's really valid. It can also be a really good tool to help keep assets separated between spouses.
Yep.
And but likewise, you might hear, my neighbor has a trust, I should have a trust. And a trust isn't right for everybody either. It is not a one-size-fits-all situation for estate planning, and understanding the tools and what fits your needs is really the best way to go about planning.
Absolutely. Often if you want trust set up for your children, if something were to happen when they were younger, those can just be set up through a will, and no trust is required to be established currently.
There's just a huge variety of trusts. So when a client comes and says, I need a trust, which of the 100 kinds of trusts do you need? And that's where an open discussion about what it is you're looking for and the type of tool that we can use to fill that need is really critical.
Yeah, and like you said earlier, 1 to 100 might not actually be the answer. It might just be a simple will.
Another common misconception is that if you have a will, your estate doesn't have to go through probate, or you don't have to deal with the probate court. And that's actually quite the opposite. A will is designed so that you can probate it and you can successfully administer an estate, but through the probate process in your state. So having a will makes that probate process go more smoothly, but you're still engaging in probate with the probate court. A way around probate is often using a revocable trust, which may or may not work in every situation. But to be clear, a probate is a probate of a will. If you don't have a will, there's a different process, or if you have a trust, there's trust administration. But the misunderstanding of how that probate process works with wills is very common, and we talk about that with clients often.
Yep, that's absolutely right. And really the only way to avoid probate is to set up a revocable living trust and then to actually title every single asset that you want in it to go in it. Otherwise, they will go through probate unless there's a joint name on the account or something like that. But essentially, unless you do the legwork after the trust is set up, you're going to have some sort of probate.
Absolutely. We see that all the time. Clients set up revocable trusts, and that's not the end. The second part of setting up a revocable trust is using the revocable trust. And the transfer of assets to that trust is a really critical part of that planning to make sure that your document fulfills your plan.
Yeah, this could require things like new deeds on real property, dealing with financial institutions to change the title on accounts. You can even title vehicles, right, into the name of a trust.
Beneficiary designations, making sure your beneficiary designations are set up correctly to coordinate with your planning.
Yeah. Now, to actually avoid probate is a very tricky thing, and few succeed at it.
That's correct.
Yeah.
That's correct. So I don't know about you, but I have a lot of clients who come in having done a little bit of internet research or having talked to friends and neighbors or family members, and they think they know what they want, and they, a lot of times they come in saying, "Oh, I need a trust." But that's not always the right answer, and it's certainly not a one-size-fits-all situation. How do you help clients navigate the decision of whether the trust is right for them, or if there are other tools that can get them to the same place or a better result?
Yeah, absolutely. For the record, I don't mind anyone doing research, but come in willing to listen to us, because we also have done our research and studying.
Right.
Yeah.
A little bit.
A little bit. I would say I start by talking to them about what assets they have. If they have assets in multiple states, that can be a trigger for me. I talk to them just about what their goals are with who they want to control their money, how they want it to be held. And then I basically talk to them about how much work they want to do now versus how much work they want their people to have to do when they're gone.
Right. And using a revocable trust is a great option, but sometimes you, as the person making the documents, aren't going to really feel the benefit, because you're really doing that planning and that legwork for the people who are going to have to take care of things once you're gone. And sometimes there's an easier way to get to that same result.
Absolutely. I mean, like you said, the benefit is often for after you're gone. And for some people, it's as simple as, my children can take care of it.
Right.
They can handle that burden. It's okay. I don't want to deal with it right now.
And I find sometimes after I've had that conversation with clients and we've gone through the assets and talked about what's really going to happen and what does probate really mean here in Georgia, sometimes the trust is the right answer and sometimes it's not. And having that conversation with a lawyer can really shed some light on what it really means in practice beyond the general advice that they've received from friends, family, the internet. Knowing something from somebody who really does it on a daily basis can be very helpful.
No, it's a great point. I used to practice up in Maryland. I got to say the probate process up there was a beast. It was not easy for anyone ever. Down here, with the guidance of people at a firm like ours, probate really doesn't have to be that big a deal.